Thank you. Okay, so the next speaker up for the presentation is Shane Duffy, who's the CEO of Aboriginal Torres Strait Islander Legal Service. Thank you, Shane.
Welcome, Shane.
Thank you, Commissioners, and I appreciate the opportunity to address the forum today. May acknowledge country and where we are today, first and foremost, and pay respect to my elders, both past, present and future, for giving me the strength to continue to do what we do. If I may, I don't like reading a whole lot. You've already got the submission, but I think for the benefit of the audience, just a general introduction, Commissioners. So obviously the Aboriginal Torres Strait Islander Legal Service, if I can give everyone a bit of a profile, we provide criminal, civil and family law services across Queensland. We've got over 230 staff in 26 locations. Obviously Cairns is our busiest office in Queensland, Townsville being our next, and then Brisbane. We're funded by the Commonwealth Attorney General's Department. We receive minimal funds from the Queensland Government, but nevertheless the Queensland Government does kick in for our higher court matters for brief out costs for counsel when needed. We're also funded from the Torres Strait Regional Authority as a statutory body through Prime Minister and Cabinet for our services in the Northern Peninsula area and the Torres Strait. But in saying that, irrespective of who we're funded by, it's important to note that we provide a joined-up universal legal assistance service to Aboriginal and Torres Strait Islander Queenslanders, no matter where they live geographically. We also provide prisoner through care services, and I may note from our previous guests that the prisoner through care service referred to by corrective services are actually provided by the Aboriginal and Torres Strait Islander Legal Service, right, not by the Department of Corrective Services. We also provide inquest activities, unfortunately, for any cranial activities for deaths in care, and we have a complaints mechanism which is statewide to deal with particularly police, the front line of defence against our people, and also within the health department, should there be any sorry business that takes place. Might I just say right from the outset that you can't arrest your way out of a social problem, and looking at the economic and social challenges that Aboriginal and Torres Strait Islander people face. And that's compounded even further the further you go out of the regional, particularly the metropolitan areas, and get into remote and very remote communities across Queensland. So we welcome the opportunity to give evidence here at the Commission today. I think many speakers before said the problem lies, as we all know, in identifying the underlying drivers or the root causes of why people come into contact with the police in particular, and then in turn with the courts, and then into a correctional facility. The challenges that we face around understanding and addressing the social and economic challenges around affordable housing, education, employment and training, disability, as mentioned before, and looking at fetal alcohol spectrum disorder, and particularly our young people who are now men and women being locked up, even though they possibly could have a mental health and or a disability, is quite obscene. Might I say right from the outset, I think I've said it to one of the commissioners there before, I'm gobsmacked that I've got to sit here and talk to people about what the issues are that get people locked up. Yeah. I'm absolutely floored. I feel like an idiot. We've got to sit here and we've got to spend money, and I know there's a process in working with government and the importance of commissioning this, but things have not changed. As each and every one of you know, the crime rates have gone down, the imprisonment rates have gone up. I think the bottom line is tough on crime wins votes. And you know, if someone was robbing my place, I'd probably want something done too. But what we do know is that Aboriginal and Torres Strait Islander people commit crimes against their own people. The crime problems we have in Cairns, I would suggest, for a lot of people that have been forced from communities for one reason or another, predominantly to access health services, to get affordable accommodation, or have access to all of those other services we talked about before. There are some solutions on the table, and we'll go into them later, and I particularly want to focus on legislative reform. We're actually dealing with those who experience the deepest and persistent disadvantage in Queensland as a minority group. There are some solutions, of course, to this, and justice reinvestment is to name but one through the Burke Justice Reinvestment to process the Marangooka Justice Reinvestment Project in Burke, which has substantial investment from the New South Wales Government, private sector investment, to actually look at addressing the root causes, the reasons why people offend in the first place. One of the challenges we have here, and I can look at one example in particular, is the amount of our people who are going to jail for unlicensed driving. So I'm not too sure of the right department, but I'll talk about transport and main roads. I know in the NPA and the Torres Strait itself, the bulk of people that are sitting in Lotus Glen and or because it's full could be sitting in Townsville or in Brisbane, in Woodford Correctional Facility are there because of driving offences. The investment from the Queensland Government is so poor in relation to going up and do driver licensing programs. Where is the common sense in all of this that they go up once or twice a year and yet they know the cost of imprisonment? So we look at, I don't know, the figures will say 120,000 a year.
107.
107,000 a year. Take 10 people out, that's $1.07 million being reinvested straight back into frontline service delivery. It's cheaper to employ a public servant to travel up into the Cape, particularly in the NPA, and get driver licence programs done than it is in locking them up. And we talk about the socialisations that they may or may not experience that already haven't been sort of in touch with their mob in relation to increased recidivism. So that's just one example. I want to talk about some of the legislative challenges, and the Aboriginal and Torres Strait Legal Service has been very proactive in this space, not only in the criminal but particularly around civil and family law services. So we're in support of the review to reduce the scope of some criminal offences, to remove sentences of imprisonment as a penalty for some offences, and to create a summary of offences as alternatives to more serious offences in the criminal code, especially when we're looking at low-level offending committed by youthful offenders. It would be ideal if a multidisciplinary consultation group could examine potential offences to remove, downgrade or limit it in their application. We're also supportive of exploring alternative approaches to addressing low-level offending that is interlinked with disadvantage or deprivation. For example, nuisance behaviour by mentally unwell is better addressed by medical interventions. Dealing with addiction is another area that calls for better responses. We often see clients who experience both homelessness and addiction, mental illness and addiction, untreated trauma and addiction, chronic pain conditions and addiction. One problem cannot be addressed in isolation from the other, so there are better, cheaper and more effective interventions that repeated contact with the criminal justice system. And as I said before, you can't arrest your way out of social problems. So breach of bail was more of a compliance. It's becoming a criminal offence. So breach of bail offences commonly lead to cumulative sentence of imprisonment being imposed, or imprisonment being imposed standing alone, given that contempt of court order is treated very seriously, and yet often a breach of bail offence has nothing to do with an act of actual contempt, but rather a court date is missed due to confusion, oversight, sorry business, mental health challenge or lack of financial means to travel. So I know that if you come to Cairns and you live on Thursday Island and you come down here and you eventually get your way home, well, more often than not, you're not going to be bailed to where you live, you'll be bailed somewhere local. What's the opportunity for someone to come all the way from TI? You and I couldn't afford to get, well, one in a motor car or a car, or pay for a plane to get back down to appear before the court. So the Bail Act could be amended incorporating a new breach of bail simpliciter offence. And our recommendation is around the factual situations where actual contempt is not at play and for which a sentence of imprisonment is not a sentencing option. So a breach of bail aggravated offence could still remain an option for genuine contempt situations where imprisonment remains a sentencing option. So we need to provide options for victim involvement as well. If we look at the DV data in Queensland, I know and I will say I am a product of DV and the way I grew up out on country because severity of the floggings that my father dished out. And I put this disclaimer in place for a very simple reason, is the data at this point in time, and the Commission has an opportunity. If you have a look at Aboriginal and Torres Strait Island data The aggrieved, I think you'll be absolutely blown away when it comes to male aggrieved and also female aggrieved. Now, that's not popular, but what I'm saying is we need to stop looking at perpetrators and victims and start looking at a holistic approach about people's rights, but more importantly, their obligations and responsibilities in healing themselves, because it's a sickness and it's an illness. So the DV is the discussion and the argument, and I don't say I throw the challenge across to you as the commissioners in your report, but it's something that the smoking needs to be pulled out and thrown onto the ground, because the result of not having adequate services that are gender specific available to women and men and their children as victims of what happens between their parents doesn't alleviate, but what it actually does is pick up the high suicide rates of our young men and our adults in the community on a day-to-day basis. Reducing the use of remand, and that's really around looking at accommodation. The challenge of us, and I note Levi, one of my staff members here in our Cairns office who provides a prisoner through care service, the challenge we've got for anyone leaving prison is alternative accommodation. So it's noted that the report that the absence of alternative accommodation was a key contributor to the number of women particularly remanded in custody, and that's at its highest increase ever. And in fact, as you know, we're at our highest imprisonment rate in Queensland's history. The same observation would hold for some men charged with DV orders, hence my comments previously. So obviously keeping accused remanded in custody in preference to anyone else is the most expensive option. Immediate relief of overcrowding in prisons could be created by more sustainable alternatives for remand, such as bail hostels. We know that it's cheaper, and I can't remember the Deloitte report, but it is cheaper to offer services in the community of origin as opposed to taking people out of their community of origin and putting them into alien environments. And another cause of higher level of prisoners held on remand are unnecessarily stringent bail conditions. The report concluded that failure to comply with these conditions, along with stringent policing of minor breaches in some locations, increased the risks of custodial remand for Indigenous defendants, with court delays and contributing to the length of time defendants remained in remand. I've been around nearly 3 decades, and what I've noticed parole and probation, but particularly in community-based orders, is breaches and compliance and people going back. I can look at our young people, even on juvenile justice orders. Governments over time, and I don't know where they had the evidence, maybe they asked the question and found the evidence that they needed to make changes. There were youth workers employed to support young people on juvenile justice orders years ago, no longer the case. The role of corrections in the community isn't about supporting the individual anymore, it's about breach and it's about compliance. I understand the philosophy, but it's a backward step. Why did it change from 10, 15, 20 years ago to end up where we are today? I might just stop there, if I may, Commissioners, and pass it over to yourselves, please.
Shane, that last list of points you made about stringent bail conditions, stringent policing, court delays, QCS breach and compliance. You've seen a significant, or you've seen it. Sorry, I don't want to lead the witness. You've seen a change in your 30-odd years in the game. So it's deteriorating. It's not improving in your view.
No, it's not, Commissioner. It's not, and maybe if I have an opportunity from our submission, of course, which you've got, but for the benefit of people. So an example, quite a number of years ago, one of our practitioners appeared in a particular jurisdiction where the failure appear rate for Aboriginal and Torres Strait Islander defendants was disproportionately high. Presiding magistrate's response was to always impose imprisonment for a breach of bail offence and would do so with ever-increasing periods in custody. The rationale was to send a clear message to the community that not turning up to court would not be tolerated. However, this sentencing regime had the exact opposite effect of that which it was intended. Failure to appear rates markedly increased. The magistrate continued to respond with ever-increasing sentences of imprisonment to make the point, with the failure to appear rate increasing still further. The reason for this became evident upon seeking instructions from clients and taking them through their criminal histories. Most of the clients did not associate their previous sentence of imprisonment or breach of bail offence with not attending court. Rather, the exact opposite. In their often confused thought process, they equated attending court with going to prison. hence the downward spiral of poor court appearances.
It's pretty grim.
Yeah.
And you're aware of the terminology gratuitous concurrence,
Yeah.
where you agree because of authority, or you think you've got to agree. Yes means yes means no, and yes means I don't know.
Yeah.
Hence the exceptional service we provide in understanding those verbals and non-verbals and those cultural nuances, depending on where we are across this great state of ours, in having our lawyers, our court support, our paralegals and administration, and our 48% Aboriginal and Torres Strait Islander employment, because we know our people. Because more often than not, they're our mob, they're our family.
Shane, that was a useful example, sort of a court example. Do you have examples in terms of interactions with the police?
Commissioner, I can give you many examples, because I can tell you now, I suppose the example I see is this: if I go down the street down here in Cairns and I see a white fella sitting there having a charge with a beer in the park by himself, you'll look, we do it ourselves, this is our own prejudice. I'm sorry, I'm not putting everyone into that category, but it's a broad statement. But if I go down there and I see a bunch of black fellas, because it's a cultural thing to hang around having a charge, first thing coppers are going to do is go over, and it starts. We call it the ham, cheese and tomatoes: resist, obscene, assault police. And this comes back to people's perceptions or a broad assumption that I live on North Stradbroke Island, and I see tourists all the time walking along the street in our little township of 300 people with beers in their hand. I can guarantee you, if they were Aboriginal or Torres Strait Islander people, perceived because of their colour of skin, because I'm fair skinned, I guarantee you the wallopers, the coppers would turn up and they'd be charged.
Has that changed in the last 20, 25 years?
No. And the biggest challenge, of course, and I'm going to say from the QPS perspective, they do a bloody damn fine job with what they have or haven't got.
Yep.
And when you're in trouble, you call the Ghostbusters, don't you?
Yeah.
So we acknowledge that. Our whole role is really looking at problem-orientated policing. I had an opportunity to present to a couple of your team members the other day the Change the Record, Smarter Justice, Safe Communities Blueprint. And it's about community policing. It's not policing the community. And it's making sure that Aboriginal and Torres Strait Islander people are front and centre in the solutions to the challenges that are impacting upon them in their communities, irrespective of where they live. Now that's smarter policers. That's problem-orientated policing. So unfortunately, it does take place.
So then, your people on community correction orders.
Mm-hmm.
So we've talked about the police, we've talked about the courts.
Yep.
Similar sort of issues, not meeting conditions, they're breached from time to time. I had, in fact, Matt, you might have been there. Was it? No, you weren't at Mount Isa, were you? Okay. One of the attendees at one of our sessions there indicated that just fundamentally simple issues, well, I say simple, but lack of literacy, things coming through the mail, not sure what they are, dates get missed, issues are not responded to, and the cycle starts again. So
Absolutely.
And there's not a lot of support out there in the trenches. I've seen some of the handout material I think you provide. If somebody's apprehended by the police, what they should or shouldn't do in those, first crucial interactions.
So might I answer the first part of the question? Because, well, I'll go back to police. I've got a memorandum of understanding with the current police commissioner, not the newly announced. One of the challenges around the Operational Procedures Manual and Police Powers and Responsibility legislation, and may I say it's increased tenfold of former governments increasing police powers, is a reference that we should be contacted in relation to any of our mob sitting in a watch house. That's not the case. We'll have instances where the police will ring up, the phone will ring once and they'll hang up because it's then recorded that they've contacted our phone. The police will send us faxes in the middle of the night, even though our office is closed. So we believe there should be legislative amendments made to legislation in direct relation to this that say the police must contact us and remove their election of choice. What we find normally, and it's being funded by the state government at the moment, the Queensland government, what we're finding is the police aren't sticking to their own agreement within the OPMs and the police power responsibility.
Shane, are there occasions when it does work well?
Oh, absolutely. Because the idea is, if someone's alleged to have committed offence, we want to make sure, and we work off philosophy and the rule of law is that you're innocent until proven guilty. And it's not this automatic assumption that you're good for what you've done. Our whole approach, and may acknowledge, Commissioner, you've had an opportunity to see the broad range of paraphernalia through our social media and marketing, our hard copy, know your rights and your responsibilities, not only in English, Aboriginal English, but also in languages from the Torres Strait, is to be able to say to people, these are your rights, but these are your responsibilities. We've been very proactive to make sure that our people understand their rights. There seems to be a perspective that comes up, and once again it was a smoky in the room to say that the Aboriginal and Torres Strait Legal Service lawyers tell them not to participate in a record of interview. Too right we do. Because we've had instances where police officers have contacted us to do a record of interview, and it all worked out. We always put our diversionary, our restorative justice principles up, youth justice, cautioning, conferencing, acknowledging there's admission of guilt. But we find out the next day that the charges that were discussed on the phone weren't even the ones that were shared with us by the officer the night before. So might I say it'd be difficult being a police officer. It's not a job I'd like to do, but I can say the continual bastardisation and misinterpretation of public policy and very, very poor legislation makes it even more valid that people, by not utilising us in records of interviews, would eventually get people charged, because we find when we are contacted, our clients have already participated in a record of interview. They get justice of the peace to come in. There's some challenges there. But we must say that with juveniles, for example, they can talk about having parents. Well, they can be subpoenaed. They haven't got protection under law to be subpoenaed to court as a witness. So there's a whole lot of, I think, intentional acts taking place by the QPS, which are quite challenging.
So there's opportunities there.
Oh, absolutely.
Significant improvement.
Absolutely. Legislation is one.
Right.
And we have learnt from the New South Wales experience is notifying people of being in custody. There was an Aboriginal woman who was subject to an inquest a year and a half, 2 years ago, that was brought into a police watch house and died whilst in custody, but wasn't officially under arrest. So the system did break down, so it needs to be further bolstered up from the learnings we had in New South Wales. Commissioner, may I just add some response to your example from Mount Isa around literacy? There's some broader political issues and interference at play in Mount Isa, and it starts at the Commonwealth Government level. Suspension of the Racial Discrimination Act in the Northern Territory for breaches under Centrelink Act. So the Northern Territory intervention, the Commonwealth's true powers through Australia's Constitution, has the ability through the ACT and the Northern Territory to basically implement certain powers. So the intervention in the Territory has been a big issue because whole families are in poverty and starving. What we've noticed in Mount Isa, and I think it was an opportune time, is a good example, is all the Yolngu mob, all the Territory mob coming across the border.
Yep.
Yeah,
So we've got the poorest of the poor, unemployable predominantly, drug and alcohol addiction, substance abuse, living in the riverbed.
Yeah.
So Mount Isa is a big challenge, and I can tell you the data that we're capturing in Mount Isa is in relation to mob coming across the border. It's not local blackfellas from Mount Isa, it's mob from the Territory. So when you've got an amalgamation of juvenile justice offences allegedly committed in Mount Isa and or possibly some from the Territory, you've got kids coming across into Queensland jurisdiction that are actually subject to child protection orders in the Northern Territory and possibly subject to child protection orders in Queensland.
as well, yeah.
So it's compounding. And what we do find, and I work off a rule of thumb, and bureaucrats may disagree, but I would suggest 70% of all of our kids that are in youth detention centre, as I always think is a rule of thumb for adult correctional facilities, are actually subject to dual orders, child protection and juvenile justice. There's an international covenant called the Convention on the Rights of the Child, and Juvenile Justice Act, as it now, it's been brought back in, the Newman government took it out, but detention is a last resort. The Queensland Labor government, this current government, has put it back in. So we've got a whole lot of issues because those kids on child protection orders are our potential so-called criminals of tomorrow once they hit the age of 10, and then they're going to move into the adult correctional facilities. So we talk about that upstream and downstream argument, and we need to address it upstream before they get to corrections, the police, ourselves and the courts.
I asked one of the other presenters this morning, were they optimistic or pessimistic about the future? Where are you? Do you have some optimism about the way things are going?
Yeah, I do. I get asked the same question, do you think you can reduce incarceration rates? No.
No.
Because I can't control the upstream.
Systems, yeah.
And, I mean, you can look at it. I look at a simple solution, albeit it's going to be a massive challenge, is the different regions of the different Queensland government agencies. They don't mimic each other. They cross boundaries. So when you're a client or you're an Aboriginal and Torres Strait Islander person, you're moving from the Townsville Health District into the Cairns Health District into the Far North Health District, then those districts are different to the Queensland housing or different to... So we have a whole lot of issues because people pass the buck. Now that's a big challenge. I'm not saying by any stretch of the imagination is it a challenge that can't be addressed, but we've got to move beyond the best intent. If we're really going to get to the bottom of this, we need to move beyond the best intent and actually start changing with a bit of transformational learning. If we keep doing the same thing, getting the same result, well, you know what it is, definition of insanity. Let's actually make sure that if we're talking about solutions, let's start locally. Let's involve Aboriginal and Torres Strait Islander people front and centre in the challenges and, more importantly, the solutions that are available in the community. And it's not always about new money. It could be cost neutral, but it could be the way the government procures services as well. And I think I was talking to someone in the audience before. I know many senior executive members of the bureaucracy that leave government, go and head up large non-government organisations, NGOs, and get a lot of money, particularly faith-based groups. And yet, if I talk about Child Protection Service, we're at a highest removal rate even before we were under the Act, pre-67. So there's massive investments, but all our data's heading south. A critical solution to all of this would be to start looking at mapping services. The success of our prisoner through care program, a marginal success in some ways, I may say, is that more often than not, through talking to my staff, they'll find out by word of mouth about who's funded for what. So I'm fortunate, I sit on the Queensland Legal Assistance Forum, and that's Legal Aid Queensland, Queensland Community Legal Centres, ourselves, the Domestic and Family Violence Services, the Queensland Bar Association, the Queensland Law Society. The challenge for us is, wouldn't it be good if I went and made a submission to the court and the magistrate, his or her honour, made a court order and we knew that the referral points were actually in existence. The success of the Murray Court in Brisbane as one, where it originally started, was that it's resourced. So when submissions are made on behalf of the client by the lawyers, we know that those referral points actually exist.
Shane, based on your experience, the Murray Court, we've seen, it looks terrific. Small numbers, I assume, are able to be handled in the Murray Court context. It looks like it's high touch and higher cost.
Yeah.
Can it scale? Can that model be scaled up, do you think? Or will it always be a small niche?
Well, you've got to plead guilty.
Yeah.
You've got to admit guilt. I think the good thing about the Murray Court is the elders that sit with the magistrate and the name and shame factor.
Yeah, they do.
And it has been successful because it's resourced. Look, they're currently undergoing a review of the Murray Court. My sense is that it's the reduction in recidivism is really high. And in fact, and without the evidence, of course, Commissioner, but I would suggest that it's far more effective than the mainstream courts.
The drug court seems to be a similar model, and they both look highly effective. The question in my mind is, can they be scaled up without prohibitive costs? Perhaps, I don't know, but it certainly seems that time between when you first present and when you're sentenced in the Murray Court And then there's a process of
that's right.
repair, rehabilitation, restoration that's gone through.
Yeah.
Looks terrific as a model.
Yeah, it is. And the success of those diversionary processes around the drug court is making sure there's services.
Yeah.
And we continually say it's services, not sentences. Commissioners, may I just say this, can I present this as evidence
Please.
to you? And I'm sorry, it's a hard copy, but
That's all right.
I can send you the
It'll be loaded up
electronic link. But we've, I don't know if you're aware, but the Close the Gap, and as I say, I'm here as an advocate for Aboriginal and Torres Strait Islander Queenslanders, but the Close the Gap refresh, led by the Commonwealth Government, an agreement signed off before all state and territory jurisdictions with the Morrison Government, has now included incarceration and child protection or justice targets within the Closing the Gap refresh. May I say the Queensland Government is ahead of the game in relation to that. The challenge, of course, is they're talking about the widgets and the numbers. The whole idea in leading a campaign, I was fortunate to be the co-chair of this without any government funds from philanthropists, and lobbied for 5 years with the Commonwealth Government. We've got it to Close the Gap, is not to say much at this point in time. It was a national approach, and that's looking at recording the same thing the same way and making sure our data sets are captured in consistency across the country. And that's acknowledging mob move across borders too. The number game or the justice targets in widgets needs to come at a later stage. So this was originally meant as a national process for the Commonwealth to take some leadership, and then for the state, sorry, I'm going between national and state, but for the Queensland Government to actually have a look at some...
Shane, I might just pull you up there, and with the courtesy of the audience, if we just go over a little bit, if people do from the audience, I don't want you to have an opportunity to ask a question if anyone here does have a question. And failing that, because we're running very close to time for the next group, if people have questions they think of later, if they can't think of one now, if they can forward it and we can get it to Shane, same as myself. Is that suitable to the group? Yep. Sorry, Shane.
No, you're right.
Thank you. Can you leave that document?
I can, Commissioner.
And is it okay if is it online?
It is online. I'll be able to send you
We can make a link to that with your presentation. We'll put that as a link to the presentation and upload that.
Commissioner, may I just briefly say the headings?
Yes.
And it's about invest in communities and not prisons. It's about local communities have the answers. Let's recognise the driving factors of imprisonment and violence. Focus on safety, services not sentences, community orientated policing, smarter sentencing, and that's what we're endeavouring to achieve, eliminate unnecessary imprisonment, adopt community justice approaches, and young people don't belong in prison. And the other two, rehabilitation is all our interests, and reintegration, not recidivism. So if I may table that, Commissioner.
Really looking forward to having a look at that.
That's a useful place to finish the formal presentation. It's almost where you started. What am I doing sitting here saying these things?
Yeah, same way, mate.
I'm sure there will be a question or two before you're done.
I think other people are waiting to present. So.
Eddie Pearce from Lifeboat Australia. Shane, not so much a question, but I just really liking what I'm hearing coming from you. I think you sound like you're a real trailblazer and barrier breaker, so I think we need more of those around the place.
Thanks, Eddie.
Thank you.
Shane, it looks like your time is done.
Thank you.
Look, really appreciate it. Another strong presentation, so thanks for that. And Eddie, thanks for being a little flexible in terms of your timing. You're our final presenter today. Thanks, Shane.
My pleasure.
Thank you,
Thank you
Shane.
very much.
Keep up the good work, mate.
Thank you.